Like the red color, yeah. So I welcome Rajeev Surana here on the board of the symposium that is been continuing since 25th March. It's a 7 day symposium, and it has been hosted by Bhupal Nobles University and co-hosted by International Institute for Advanced Legal Studies. Host universities chief coordinator indeed, I Dr. Jayashree Singh from Department of English, and the Dean Faculty of Law is the organizer, along with our Reverend President, Professor Naresh Bahadur Singh ji, Registrar Shri Parvat Singh ji Rathod. They are also the facilitators of this program, and Dr. Kamal Singh, Public Relations Officer. He is also to be here for extending word of thanks at the end of these sessions. And a lot of faculty members of all across, you may say, Udaipur region have contributed in this day by day with their discourse or with their some kind of help or guidance to us. And as we have contacted you, Dr. Rajiv, as a senior advocate, I would say a senior advocate is in itself a flying feather or to your cap that enhance your status, position, as well as your intellect and insight with regard to the legal studies expertise. So I feel that you are really a guideline and a beacon to initiate a different kind of talk today, which we have not got for the last 5 days, and it is on land revenue, property, tax, and liability, etc. So I welcome you, Dr. Raji. Please carry on with your discourse.
Thank you so much, Jayashree, for inviting me on this symposium, and it is a great pleasure for me to participate in this great feat that you have the great foundation that you have laid. Now, as far as the topic is concerned, with regard to the civil laws and its variable, uh, it's a very vast topic, and I would rather uh, restricted to a certain spheres, because otherwise it will be a very big discussion, and it will be time consuming also.
Rajiv,
So
could you speak loudly, little loudly, and
yeah, am I
come
audible now?
closer to the screen also?
Am I audible?
Yeah, you are audible, but your voice is low and you are a little apart from your laptop screen. So be closer and
Yeah.
speak little loudly.
So uh, the first comment I want to make is that any civil liability is prescribed by the law, and law is what one has to do and what one has not to do, and what one entitles to be get done from the law. There are rules and acts for this, and a breach of rule is called a wrong. When a person is committing a wrong, he is said to be liable, and liable is a condition of the person who is who has committed a wrong. Now there is a difference in the nature of remedy that is applied. An act may be a penal act, and it might have a civil consequences also. A crime is a wrong against a society, and a civil liability is against a particular person. So in Indian law is very much advanced, and as far as the liability can be classified in the form of penal or remedial. The distinction now has to be made on the basis of legal consequences of the action against the wrong. Now, the liability is based on the maxim ubi jus ibi remedium. Where there is a right, there must be some remedy. When law creates a duty, it ensures its fulfillment also. So therefore, there are many laws, civil laws that have come up, and in India, it is in a very developed state. Now there can be, Jaishi, there can be acts of various kinds. Like there can be a positive or a negative act. There can be a voluntary or involuntary act. There can be an internal or external acts, or intentional or not unintentional acts. All have been dealt with. But now, more particularly, we would be dealing with the property laws and the revenue laws that we have in India. As you are aware, as far as the revenue laws are concerned, revenues laws come under the state list in Schedule 7 of the Constitution of India. And Article 246, Subclause 3 makes states to confer the power to make laws on the revenue law. And the center or the parliament does not have the right to legislate, because there is a thing going on that there has to be a uniform revenue law. After every 20 kilometers in India, there is a diversity and there is a difference. Uh, and as far as states are concerned, they have got their own, just a Rajasthan State Land Revenue Act we have. So, but there is a catch in this. Under Article Clause 1 of Article 252, two or more states can ask, or they can agree that the center makes laws, provides for delegated legislation to and more states to enable the legislate on the state list. So if all states agree and they pass a resolution to the effect that then the parliament can pass legislation of a uniform land revenue system in the whole of India. Normally, as far as the land revenue disputes are concerned, what is my experience from last 28-30 years, that there are two individuals, and one is having the rights of ownership and one is claiming to have. Now, now it is now it is desirable that in India there is a uniform land revenue system, but the country which is marked with plurality, it seems to be very, very difficult. There is no consensus, and there is a split between the castes, and there is no homogeneity of personal laws. So, in this context, if all the states agree, then the parliament can pass laws. Now, as far as civil remedies are concerned, normally it comes into the sphere of the Transfer of Property Act or the Indian Contract Act. And as far as the Transfer of Property and Contract Act are concerned, there are so many other laws that have been passed uh, to facilitate what earlier used to be the remedy. Like for example, for banks, the Surface I Act has been passed, the Securitization Act. In short, it is called the Surface I Act, where the banks can claim the property, and there is a easy way to take back the debts that have been incurred. So the Surface I Act is there, but normally there is a controversy which law will prevail. For example, in a property, if there is a tenant, then whether, as far as the Surface I Act, whether the bank can evict the tenant, that is not possible. The rent, it is not, Surface I Act is not over and above the Rent Control Act. But as far as the Arbitration Act is concerned, it goes hand in hand with this Surface Act, and any person has a choice of election. If the bank wants to go for the arbitration, it can go for the arbitration. If it wants to pursue the remedies under the Surface Act, then that is also possible. Uh, there is one more thing. There are so many spheres uh, where there is no specific law or there is no specific rule, and there is a gap which has been left by the legislature. Now, it is sure that the courts cannot legislate. It is not in the domain of the courts to legislate. The courts can interpret laws, and in such interpretation, certain creative process is involved. Courts may also fill up the gaps in certain spheres, applying the doctrine of constitutional silence and abeyance. But the courts cannot make the policy. Courts will not plunge into policy making. So, there, as we have seen in the COVID times also, there were so many orders that were passed by the Honorable Supreme Court, and there were not enough legislations or not enough acts, and so therefore the courts filled up the gap where the legislature did not provide for a particular contingency.
Okay.
And that has also that is also a limited aspect that the courts can do. But certainly the Honorable Supreme Court passed so many orders. Even the Honorable Supreme Court passed the orders in the existing acts, for example, Limitation Act, that the Limitation Act will not apply and it was kept in abeyance. So that the Supreme Court can do, looking to the extreme contingency which the legislature has not thought of. So our courts and our system is, with regard to judicial ruling, is very advanced, and it has come up to the times and have reflected very well and have responded very well, and it has a learning experience, and the legislature can take cues from the active and uh, certain judgments that have been passed, and can implement and can pass perfect laws with regard to that. For example, I'll give you an example. In matrimonial laws, normally there is civil litigation also and there is criminal litigation also, and certain at a certain stage there are 8 or 9 or 10 cases that are filed, but ultimately after 2 or 3 years it results into, you know, some sort of an agreement where the parties do not want to go any further, and so a compromise is reached, but there is no procedure that by a push of the button each and every case is solved at one go. Now, I had written an article also on applying Six Sigma in the court procedures, where the unnecessary and unproductive processes can be done away with uh, by applying Six Sigma in the court proceedings also.
Could you
And
explain us Six Sigma? What are these six sigmas?
Six Sigma is a, is a process, is an ideology where it's a Japanese thing, that in any company, for example, in any factory where there are unproductive processes, they look for the unproductive processes and they remove it. I can give you an example if you want, what actually
Yes, sir.
Six Sigma means.
Yes, sir.
For example, if there is a blackboard in front of
Hmm.
you and a person
Hmm.
is sitting in the chair and
Hmm.
he has to go and write something on the board.
Hmm.
So he goes, he picks up a chalk and writes that thing.
Hmm.
So Six Sigma means to look at the whole process and say, "Well, why do you need to sit?
Hmm.
Remove the chair. You can directly stand there." Now, if you pick up a chalk and you pick up from the left hand side, it will be difficult and take time. If you pick it up from the right hand side, it will be easier. So
Hmm.
place those things at the right place, and so it is a process where unproductive processes are done away with, and that is a big example of Bombay Dibbawala, where
Lunch boxes.
lunch boxes, where he supplies the lunch boxes. It
Hmm.
is it is the exact menu, it is the exact time, and there is no failure. It is
Hmm.
a very big study uh,
Hmm.
that can be done. Uh, so, but let's get back to the topic.
Yes, sir.
And and where I was saying that it's not in the domain of the courts to legislate, but certain areas the courts have gone and have implemented and have filled up the gaps by the creative process which is involved in when interpretation of laws is concerned. So uh, as far as the and we also talked about the land revenues laws. Where is the glitch that is there for a uniform revenue uh, code?
Hmm.
Because the state has got the power to legislate and not the center.
Hmm.
And then we have also adverted to the civil remedies. That are civil remedies are basically uh, in the sphere of individual rights and wrongs that have been committed, and whereas the criminal liability is pertaining to the act against the society and it involves a guilty mind.
Hmm.
So I would be very happy, Jayashri,
Yeah.
if there is any question from the forum that I can answer. And I'm really happy
Hmm.
that you have invited me for the symposium. If anything is there, you can ask, and I will reply. I am happy to reply.
Uh, may I just intervene in between? Actually, Professor Salvatore is going to his office. He's on his way, and he would join by 7:15, and he would talk to you. But he has requested on his behalf that you continue with your deliberation, and he would be joining in by 7:15 to have an interaction with you. And here we also have Prema Priyadarshini, who is listening to you, so she would definitely would like to later on float some comment upon your whatever discourse you are delivering to us. So you better keep continuing with your lecture, because you have set a background for us with regard to your topic that you wanted to convey to us, Land Revenue Act. Now, how the
Land
act,
Revenue Act, banking laws,
yeah, how
even
all these things historically, constitutionally, and then socially, economically been into existence, and then finally how the tort liability is is an influencer uh, from the point of colonization or from post colonization, and then finally 21st century has turned up, and what are its new amendments. If you can throw light on all these things.
yeah, sure. So, like when India became independent and the Jamidari and Biswedari Abolition Act was passed, all lands were vested in the tenants, the persons who were, cultivating the land. They were called Khudkasht tenants and khatedars. So immediately on the passing of the act, large properties which were under the Rajas, Maharajas, and the Zamindars, they were taken away, and the people who were cultivating the land. So normally, as far as Rajasthan is concerned, the biggest beneficiaries were the a particular community, Jats, who were normally, well built up, and they were cultivating the lands for the Jamidars, and they were doing all the cultivation, and they suddenly became owners of the land. And this is the major change that happened. Not only uh, the they were oblivious, the jamidars and the other rajas and maharajas were not oblivious with the change in the scenario. There was a sudden change because we got independence, and suddenly these acts and major acts came, and so they were not oblivious. They wanted to save their lands, and so certain lands, they, you know formed societies and instituted universities and tennis courts and dedicated and changed their use to, avoid from getting it into the framework of giving it away to the tenants or the khatedars or the khudkast as per the act. So there, it is no doubt that certain Am I audible now? I can't hear anybody. Am I audible now?
Now you're audible.
Yeah. So I think I miss. You must have missed the entire point. If my
Please repeat.
Yeah. So I was talking about the act that came, Jamidari and Viswadari Abolition Act. I hope you must have heard that much. So
Mm-hmm.
so what happened was that in a single day, the persons who were cultivating the land, mostly the Jat community and the other community who were, really cultivating the land, they became the khatedar tenants, and they became the owners of the land. And the zamidars and the raja maharajas and all the people, the entire land was taken away, and they were left with nothing. And as far as the agricultural land is concerned, and after that, it is not it is obvious, and they were not oblivious of the fact that their lands are being taken. So some of them who were, really intelligent, converted the use of the land and made a society or instituted a university. For example, a university, Gandhi Vidya Mandir, is there in Shadar Shahar. It has got 20,000 bighas of land,
Mm.
and some of them where there was no agricultural land and there were killas and all, they converted it into, you know heritage hotels and everything. So there was a massive change, as far as the ownership is concerned, on account of you were talking pre-colonization and post-colonization. Post-colonization, when we got our freedom, and when these acts were passed,
mm,
then the Settlement Act came,
mm.
and people were, uh, entered their names in the as a khatedar. So, as far as the revenue laws is concerned, there was a massive big change as far as the ownership is concerned. So, normally, what we have now is dispute between individuals, one who is having rights of ownership and one who is claiming the rights of ownership. So normally, what I was talking about is there is a change in every area, every state. There is a change of revenue law, and I earlier deliberated upon the fact that there has to be a uniform revenue law, and but that is very difficult because the state has got the power. It is in the under the subject of the state list under Schedule 7 of the Constitution of India, and Article 246(3) makes the states to confer power to make laws, and but there is a catch, and the catch is contained in the Constitution itself, that if two states concur and are agreed, then the center can pass the law. So if all the states agree, there can be a uniform revenue code also. There is a possibility that there is a uniform
So
revenue.
do you take cases of state revenue, or do you take other kinds of individually?
Normally, what cases I get is they travel from the SDM to the Revenue Appellate Authority, then from Revenue Appellate Authority to the Board of Revenue, and from Board of Revenue a writ comes to the High Court. So normally we deal with the writs. So it has passed all the stages
Hmm,
of adjudication, three stages of adjudication in fact,
yeah.
and then it comes to the High Court. So those are the cases that we are dealing with at present,
So,
and those
in Jaipur, is there the post of sub registrar of revenue? Like my husband, he was sub registrar in Udaipur. He was not SDM. It's a sub registrar revenue, state revenue system.
normally
It puts
normally
RS officers into. um
in the hierarchy of revenue laws, the first authority where the case is filed under Section 188, or for that matter for any other section, with regard to the either correction of entries or with regard to the rights in the revenue land, is before the subdivisional magistrate, SDM,
okay.
and then thereafter an appeal is provided to the Revenue Appellate Authority, and thereafter the revision lies before the Board
So
of Revenue.
SDM basically dealing with the revenue uh, process of revenue jurisdiction, and registrar sub registrar is actually dealing with the collection of revenue from the regions that he has been deputed, like particular zone he has been deputed to collect the revenue. So there is a difference between sub registrar and the SDM
Sub registrar
duties.
is dealing with the stamp duty that we pay when we get a sale deed registered. So he would be adjudicating on whether you have paid correct stamp duty, correct court fee, correct duty or not to the government, which is
So here
applicable.
actually our focus is here on this point, where actually your lecture should start from here, like how the land and property tax in lieu of or in influence of affection or of some kind of transferring to the survivor the property. Here, actually, we wanted from you certain kind of.
So, okay, now you are talking about the hereditary rights,
Hmm, it comes under
the
tort,
rights the
law of
of the
tort.
survivor or the legal heir.
Yes, the law of
Now,
tort now
normally what
starts.
happens, Jayashri, is
Hmm,
that whenever there is a land, if there is a revenue land or any land for that matter, uh, it is regulated either by a will, that is wasiyat in wasiyat, and which is the declaration of the person who's making the will, that to whom the property will go. And either it is an unregistered will or it is a registered will. So if it is a registered will, the presumption is in favor of the registered will. Even if it is an unregistered will, then it has to be, if it is challenged, then it has to be proved in accordance with Section 68 of the Evidence Act, which is very clear. And then if there is a will, then the person has to, normally take a probate. But normally in Rajasthan, nobody takes a probate. I mean, not nobody. Some people take a probate, but the process is very cumbersome. They have to ultimately pay the, according to the value of the property,
hmm,
the duty,
hmm,
because ultimately the direction is given for registration,
hmm,
and then it comes to great deal, because the property has risen to crores of rupees, and like people are not able to really pay. So what they do is, on the basis of a will, even
hmm.
if it's registered or a registered will, they would execute a sale deed and then get it registered
Okay.
if they are selling the property.
Hmm,
So that is how it, or if there is no will, then as per the Hindu Succession Act, as far as the Hindu is concerned, a succession certificate can be taken from the district judge. But those proceedings are also there, because that also entails a big amount of fees. So the process has, the legislature has not even ever thought about a smooth handing over of the property to the legal heir, or to the person who inherits the property
hmm.
in accordance with law. So that process is very cumbersome. I am, because even I lost my father last year in the first wave,
Yeah.
and he was a senior lawyer, and
Hmm,
he had certain properties
hmm,
and certain bank balances and certain things. So it was, and in every bank we had to, do the entire process of indemnity bonds, and people vouching for us, giving affidavits who were, already having bank account there. And
hmm.
for a normal person it is very difficult.
Yes.
I am a lawyer, so it was managed very easily, but
Hmm,
it's a cumbersome process, I should say. And there has to be a land bank, and has to, the legal heirs can be listed there, and it can be an easy process, it can be digitalized
hmm.
without affecting so much of chaos which is happening. So the legislature has not thought of any smooth process. So these are the things how they are going now at present.
Right.
Yeah.
So meanwhile, we can do one thing, that let's halt in between. We invite Senior Advocate Prema Priyadarshini to continue with her discourse. And if
Sure.
our co-host enters in, we will again have a conversation and interaction further. Okay.
Sure.
Good evening, ma'am, and good evening, Rajiv sir. My first of all, my condolence, sir. I just heard that you have lost your father. And ma'am, thank you so much for giving me this opportunity. I'm really humbled and honored to be part of this symposium. I don't know uh, how much justice I can do with the topic, but whatever topic has been given, I have worked hard and made the note. So before I go and speak on my topic, there are two questions. If Rajiv sir can, he has really wonderfully he has concluded the and still the journey is on from pre to post of the revenue act, and in a very nice manner he has laid down all the amendments and how and what are the lacunas also. When we practice we see that in act there are many loopholes. So as a practicing advocate, and even sir will feel that we are having those lacunas. So only one question, because I'm in Delhi and we are facing so much of heat in March. Everyone is saying that it's 42 degree, and it should have been in June, but it seems that we are in June. So I was just wondering, what are the laws to protect the forest? Is some amendment in the Revenue Act where agricultural land is being what you say is just being taken by the urban or in urbanization? Is there some protection so that the global warming and the heat which we are experiencing can be reduced? This is the only questions I have.
Yeah, as far as here in Rajasthan, I can answer. There are zones, and there are some green zones which cannot be sold off or which cannot be, converted for any use. So we have our master plan, and there is a judgment of the Jodhpur High Court that the master plan has to be adhered to. And as far as and then we have our own environmental laws, as you are aware, where you cannot, every day we are seeing that the PILs are filed, and there is much development that the lands of Nadi, Nalas, and the lands of pasture land, that cannot be taken away. Pasture land can be taken away if you create another pasture land. So so it is not easy, and there is a very strict grip of the law as far as but you're right. If there is a private land and a person wants to file an application under section 90A, 90A of the Land Revenue Act, 90A, for conversion of the land into Avadi land, he can do so. As far as agricultural land, there is no such restrictions, but everything has to go in accordance with the master plan and the zones which have been created. They have created different zones. There is a green zone, there is a forest land, and then forest land. After forest land, there's a particular in the after the forest land area, within 25 miles you cannot make any commercial or any construction uh, that is there. So by and large, as far as Rajasthan is concerned, I know that the areas is protected, because we were having Aravali hills here, and there was indiscriminate mining also that was happening. So the court also, uh, put an embargo on that. How the It cannot be just like, indiscriminate cannot be done, and the mining department was put to task on that. So by and large, here in Rajasthan, we have a protection of the green belt.
Thank you, sir. So at least we are part of that judicial system which is trying to strike a balance between man versus nature. We can,
Quite
in
right.
a way try to protect the land also.
Quite.
Bharat Mata ko kahin na kahin we are giving that protection.
Thank you, Prema, for
Thank
such a
you.
wonderful question.
Yes, sir.
It is what
Because
deep
I'm
rooted, and
sitting
it
in
shows
OC.
that how you are concerned with the environment, Uh, Really, it was very amazing question, and I would like to reflect more on that
Yeah.
Have you,
once you are.
Rajiv, have you ever taken any kind of this climatic or nature resource property kind of cases, natural
Yeah,
resources?
we did a PIL, we did a PIL, we were the first ones to do a PIL,
Hmm.
this Baramda case of Jaipur, the famous Baramda case. Uh, we
Acha, that
filed a PIL,
Jhari
and then
Bazaar, Jhari
the,
Bazaars,
the,
all
the
shops.
shops, they had, come encroached upon the Baramda
Mm-hmm.
and then extended their, and they had, really uh, spoiled the entire old architecture uh, in the city. And then we were the ones who filed PILs against encroachments and minings in the river areas and in the areas where you cannot, where there's a green belt. So petitions were allowed, and so we see Jaipur as beautiful as it is today.
Yeah.
Yeah.
So here we have with us our co-host, Professor Tolone Azzariti. Um,
Good evening. Good evening, sir.
Good good evening. Good evening. Can you hear me?
Yes, yes.
Yeah.
You're quite audible.
Good evening by your side. Good morning by mine.
Oh, what is the time there?
Here we have 11 a.m.
Oh,
Oh, great.
we are at 7:30 p.m. in the evening almost.
Yeah. I know this. I know this.
Dif-
I know this.
different time zone, but yet we are together in the symposium. That's great.
Yeah, the great of connection today.
Yes.
we will continue with our discourse that has to be delivered by Prema Priyadarshini, Senior Advocate from, and she's arbitrator, mediator, and in High Court of Delhi. And of course, Rajeev Surana, he's also a senior advocate, lawyer at Jaipur bench in the, you may say, High Court jurisdiction of Rajasthan. Am I right? So both
Yeah.
of them are
Rajasthan High
very
Court.
much senior in their expertise as well as in their deliverance to and services to legal studies. Rajiv, we will continue with your little half of the lecture later on. Let's continue first with Prema.
Sure.
Okay, so the topic which was given today was liability of employer, insurance, and compensation. So I have really tried to simplify it, and I hope when ma'am will circulate it with other law students, they will be easier because they are students. I don't want to go into very technical and high legal language. I want it to be very simple for them. So I have prepared that note, ma'am. So, the employment relationship is the legal link between employers and employees. It exists when a person performs work or services under certain condition in return of remuneration. So, this is how the relationship between employer and employee is defined. It is through the employment relationship, however defined, that reciprocal rights and obligations are created between the employee and the employer. It has been and continues to be the main vehicle through which workers gain access to the rights and benefits associated with employment in the area of labor law and social security. The existence of an employment relationship is the condition that determines the application of the labor and social security law provisions addressed to employees. It is the key point of reference for determining the nature and extent of employers' rights and obligations towards their workers. The issue has become more and more important because of increasingly widespread phenomenon of dependent workers who lack protection because of one or a combination of the following factors. The scope of the law is too narrow, or it is too narrowly interpreted. The law is poorly or ambiguously formulated so that its scope is unclear. The employment relationship is disguised. The relationship is objectively ambiguous, giving rise to doubt as to whether or not an employment relationship really exists. The employment relationship clearly exists, but it is not clear who the employer is, what right the worker has, and who is responsible for them, and lack of compliance and enforcement. So, all these factors result in the problem which the employers and employee both are facing today. There are ambiguity in the present law. To address these issues, a general discussion took place on the scope of the employment relationship in 2003 and in 2006. The International Labour Conference adopted the recommendation concerning the employment relationship. This recommendation covers the formulation and application of a national policy for reviewing at appropriate intervals, and, if necessary, clarifying and adapting the scope of relevant laws and regulations in order to guarantee effective protection for workers who perform work in the context of an employment relationship. The determination via listing of pertinent criteria of the existence of such a relationship, relying on the facts relating to the performance of work and remuneration of the worker, notwithstanding how the relationship is characterized in any contrary arrangement that may have been agreed between the parties, and the establishment of an appropriate mechanism or the use of an existing one for monitoring developments in the labor market and organization of work, so as to be able to formulate advice on the adoption and implementation of measures concerning the employment relationship. Employers' obligations towards employees. Now, I want to speak on that. What are the obligations of employers? Then I will come on the duties of employees as well. Every employee, labor, or workman at the workplace has been granted many rights and privileges by different statutes under law. The same rights result in corresponding duties for the respective employers. Thus, along with rights to employees, law has also assigned certain duties to the employers in order to ensure a harmonious relationship between the employers and employees and increase the efficiency of work at the respective workplace. Employers' liability insurance is part of workers' compensation insurance. Workers' compensation insurance policies usually have two parts. Part one, workers' compensation insurance pays for medical expenses and partial lost wages from work related injuries and illness. Part 2, employer's liability insurance. This coverage provides the business owner protection if company is blamed for an employee injury or illness. So both for workers and employers there are two insurance for the compensation. So both are protected equally. It's not only the workers, even the owner of the factory or owner of the industries, they are also protected. Management is also protected. Employers liability insurance covers legal defense cost when an employee blames business negligence for their injury or illness. Those costs could include hiring a lawyer, court fees, and paying a settlement or judgment. For example, a software developer could file a lawsuit over carpal tunnel syndrome from constant typing, or a restaurant chef could sue for over a burn caused by a faulty fryer. For either case, workers' compensation would pay for medical bills and part of the wages lost while the employee recovers. So, how this, I'm just giving a very current examples which we can relate to. But if an injured employee thinks that negligence caused their health issues, they might sue for punitive damages like pain and suffering. That's where employer's liability steps in. Which claim does employer's liability insurance cover? This is a question. Employer's liability insurance covers negligence, lawsuits over work related injuries, and occupational disease. In other words, if the employee sues over an injury, this policy will pay your legal cost. When employees receive workers' compensation benefits, they usually agree not to sue their employers but that doesn't mean you are immune to lawsuits. An employee directly suing their employer is only one type of lawsuit, and employer's liability covers you. They may face a few different forms of legal actions depending on particular field and type of business. There are variety of new types of insurance one want to consider once they become an employer. Now there are so many types of insurance cover. It is in the present, after post covid era, there are many other coverage I am seeing now. Every day we are also vetting those agreement. The most likely to need, however, is workers compensation insurance, and it is almost definitely required by law. So workers compensation insurance is the most important insurance. And then there is also employers liability insurance. So these two insurances are very, very important. So the question arises whether employers liability is the same as workers compensation. So this is a question now coming in everyone's mind. And what is the difference between workers compensation and employers liability? And what is the employer's liability? Is it one section of workers compensation? How does workers compensation work for employers? So these are 3 4 questions which will come in anyone's mind. So for answering that, I want to go to the second part of my note. So, what is the difference between workers' compensation and employers' liability insurance? It is that employers' liability covers more. Workers' compensation and employers' liability insurance both cover injury in the workplace. But to get workers' compensation paid out, you don't have to prove negligence. In practice, that means that workers' compensation covers accidents that can be prevented, while employer's liability covers a wider range of claims against the employer. So it is a wide, employer's liability is covering more, protecting more. So that's it, the answer of that. I think there's some technical thing coming in. I might have to stop for a few minutes, ma'am, if you could permit. Just for a few seconds, I think.
We are not finding any issue. So, hello Aishwarya, are you there?
Sorry, I thought a little shaky something. Now it's fine at my end. Yes, ma'am. I'm very sorry for that technical issue. So, example, I'm just now coming to the example of employers' liability versus workers' compensation to, because only these two people are involved, employers and employees, between this insurance also. So these two are the main hero here. I don't know who will become villain, but yes, I'm dealing them as heroes in my note, not as a villain. So let's say an employee falls off a ladder at work and breaks a leg. So workers' compensation will cover their medical bills and maybe even loss of income while they recover. In this scenario, there are still a lot of ways that employer's liability can come into play. Before the fall, the employee had warned the employer that the ladder was in bad condition, but the employer had gotten around to replacing it with a safer one. So this may, they can say no, it is a negligence. It's not, because I already reminded them, but then also ladder was not, rectified. They did not repair. The ladder company pays the medical bills, then sues the employer who owned the ladder because the ladder was too old and should not have been in use anymore. So although the employee get the benefit of that coverage, but then employer has to face the brunt of the ladder company. The injured employee's spouse is taking care of them and runs over their own foot with the wheelchair that the injured employee is using. Now, the spouse has their own medical bills. So, what happens now? The employer is a ladder manufacturer. The employee is suing as both an employee who has on the job and a user of the product. Now, because of the mistake of employee's spouse, the wheelchair, because he has injured his leg, he is on the wheelchair, and by mistake, accidentally, that wheelchair hurt the foot of the spouse. So now who will be responsible? Now the employee started case against both. Now both, because now the spouse is also hurt. He wants that coverage now. So all these things, nitty gritties happen every time. Employer's liability to pay compensation. The employer's accountability. Now I'm coming with more with Indian context. I will be citing the sections, reading out that. It was a general thing. Now, more particularly with India, the employer's accountability to compensate an employee arises under Section 3 of Employees Compensation Act 1923. Under this section, five prerequisites are enumerated, upon satisfying which the employer shall be accountable to pay compensation to an employee, which are following. So, the five grounds under Section 3 of the Act is laid down by our Parliament. What are those five grounds? If number one, if a personal injuries has been sustained by an employee. So what is that? If an employee while functioning in an establishment has sustained any personal injury, whether or physical or psychological, by an accident, then employer shall be liable to compensate such an employee. Personal injury has not been defined under the Act. However, a personal injury is an injury caused to person's physic, intellect, or reputation. So, both, not only physical but also psychological. Person's physic, intellect, or reputation due to a person's negligence or illegitimate conduct. So, personal injury does not include an injury to someone's personal property. Common examples of such an injury may include motor vehicle accidents, plane and railway accidents, accidents at employment, product defects, medical accidents, libel, slander, etc. According to this act, personal injury also includes occupational diseases. The case of Indian News Chronicle versus Mrs. Lazarus is a celebrated case in which the court defined the scope of personal injury caused to any workman while working in an establishment. In this case, the workman went to a cooling room from a heating room and contracted pneumonia, and he died within a span of 5 days. The court in this case held that the workman died due to a personal injury. A personal injury includes a physical injury. Although it is not very clear, the definition is not very clear in the Act, but the judgments later on has interpreted what is physical injury. So now the courts have come and interpreted the Act. Second is, if such a personal injury has been inflicted as a result of an accident. In order to demand compensation from an employee must substantiate that those personal injuries have been resulted out of an accident while executing his indispensable duties. The term accident also has not been made clear under the Act. Now, the term this is also not clear. An accident is, in normal parlance, can mean as an unexpected event that results in harm to some person. An accident cannot be predicted as to enable any person to save themselves from any kind of harm or injury. Likewise, an employee cannot predict an accident which resulted in an injury to him. Therefore, it is a responsibility of an employer as a principal to render any compensation to an employee in case of such an accident. Third, if such an accident has arisen out of and in course of an employment, the most essential requirement of getting compensation from an employer is to substantiate that the accident has been caused out of the employment or during the course of the employment, respectively. It does not suffice that an accident had been caused to an employee. It is equally necessary to prove that such an accident resulted out of the employment or in the course of such employment. An employer is not entitled to compensate an employee on the basis of any accident alone. It might be the circumstance where the injury has not been resulted during the course of an employment. The onus of proving that the harm is caused out of or during the course of an employment is only upon the employee in this situation and not the employer. The employee has to substantiate his case in front of the court. Onus is on the employee to prove that the injury has been caused the employment during the employment and not any other accident. If he has gone for some personal visit, or he in his personal time, and some accident happens, employer cannot be held responsible for that accident. The law act has been very clear what when the he will be employer will be liable for compensation. Liability of compensation only arises in these five categories which I am reading. I am on third now. It is necessary in the current situation to understand the meaning of the expression arising out of the employment and in the course of employment. So, what is arising out of employment? The expression arising out of employment refer to those incidents where there exists a relationship between the conditions under which the work is required to be performed and resulting injury. In simple words, there must be a connection between the harm and work the deceased was doing. The accident must have resulted out of that work only. It is also necessary to satisfy a court that if such a person has not been doing that work, the injury will not cause to him. If both the conditions are satisfied, the court will grant the employee the right to claim compensation from the employer. So these grounds have to be satisfied before the court by the employee to get compensation from the employer. The onus is on the employee now that this accident happened and how it happened. In the case of state of Rajasthan versus Ram Prasad and another, the death of the employee was caused due to natural lightning struck at him. The court held that the employee shall be liable to receive compensation as he satisfied the dual conditions. The lightning struck at the deceased when he was in the employment of the employer, and if the deceased had not been in workplace where the lightning struck him, the deceased would not have died. Even in this, when he died due to this lightning, the court held the employer responsible because he was at work place. So even in this ground also, when it was by the act of God this happened, but still employer had to pay the compensation. So in the course of employment, to make an employer liable to pay compensation, the workman has to substantiate that the work performed was identical with the time and place of employment. In other words, the employee has to prove that the work was done during the working hours of the employee and at the place of the employer. So these two are very important: working hours and where at the workplace. The employee also has to prove that he was executing his duties for the benefits of the employer. In the case of National Iron and Steel Company Limited versus Manorma, a boy was working on a tea shop which was situated outside the factory premises. His duty was to provide tea to all the workers placed in the factory. The boy, while coming out of the premises, passed a violent mob of workers. The police, in order to protect themselves from the attack of workers, fired on the mob, which also hit the boy and he died instantly. The court held that the deceased shall be liable to compensation as he was working during his working hours at the place of premises and also he was executing his duties for his employer. So, fourth category: if such an injury resulted in permanent or partial disablement of an employee for a period exceeding 3 days. If an injury caused to an employee from the accident result in his permanent or partial disablement for a period in excess of 3 days, then the employer shall be liable to render compensation to such employee. The permanent or partial disablement has been defined under Act subsection 5. Partial disablement can be both temporary and permanent. When the disablement is of temporary nature, such disablement reduces the earning capacity of the employee in any employment in which he was engaged at the time the accident took place. And when the disablement is permanent, it reduces the earning capacity in every employment he could engage when the accident took place. This is the fourth category which is laid down in the Act, subsection 4 of Section 3. Now we come to subsection 5 of Section 3. If such an accident resulted in death of an employee, the last requirement which will enable the hires of employee to receive compensation is to prove that such accident resulted in death of the employee. If it is proved in front of the court that the death was caused by an accident occurred out of or in course of employment, then the hires of the employee shall be entitled to receive compensation. So these are the five categories laid down by the Act. Now, what are the exceptions? There are also certain exceptions to the above prerequisite. So we have to see what are the in what cases this will not be given. The Act, along with the prerequisites, also listed few exceptions in order to safeguard the employer from paying compensation, which are as follows. The injury which resulted from an accident does not result in total or partial disablement of an employee for a period in excess of 3 days. So we have already seen when that should be given. So the injury does not result in death of employee. The employee at the time of accident was drunk. The employee intentionally disobeyed any rules or regulations framed for the safety of the employees, and the employee intentionally disregarded or removed the safety grounds framed for their safety. If these grounds are there, then they will not be, employers will not be held liable for the compensation. Liability of an employer in case of an occupational disease. The Schedule 3 attached to the code to the Act describes some occupational disease in three parts: A, B, and C, peculiar to the employment. If a case of an employee falls under Schedule 3, then the employer shall be liable to pay compensation to the employee. These occupational disease mentioned in the schedule connotes that they shall deem to be injury by accident when any question appear before the court regarding the liability of an employer as against the employee. Part A of Schedule 3, where the employee is in the employment specified under Part A, contracts any occupational disease, he shall be liable to receive compensation from the employer. Part B of Schedule 3, where the employee is in the employment specified in Part B for a duration of not less than 6 months, contracts any occupational disease which arose out of the employment, he shall be liable to receive compensation. Part C of Schedule 3, where the employer is the employment specified under Part C under more than one employer for a period as may be specified by central government, contracts any occupational disease arising out or during the course of employment, he shall be liable to receive compensation from the employer. Liability of employer after cessation of employment by an employee. So what happens then? What is the liability of employer? Quickly, I will go through that. Part A of Schedule 3. If any employee after he left the employment contracts any disease specified in Part A, he shall not be liable to receive compensation from the employer. Part B of Schedule 3. The following conditions has to be satisfied by the employee in order to receive compensation after he left the employment. The employee has been in employment under an employer for not less than 6 months. The employee, after he left the employment, contracts any disease specified in Part B, and the disease arose out of the employment. Part C, the following conditions has to be satisfied in order to receive compensation after he left the employment. The employee has been in employment under one or more employers for a period as many as may be specified by central government. The employee, after he left the employment, contracts any disease specified in Part C. The disease arose out of the employment. So I have dealt very briefly and quickly in a very plain language for these law students who can hear this and understand. So what are the liability and how, what is the basic thing are only two things: employers and employee, and employment relationship agreement. These three ingredients are the main focus of this topic, and the law is very clear. Sometimes law is not clear, then the court has interpreted, then certain judgments are there which can be referred to make any terms clear, and ambiguity has been removed. So if anything else, ma'am, because I thought that I think I have taken not more than the scheduled time. I was very worried I should not take. Ma'am has given me 30 40 minutes, 30 minutes to be precise. So that's
Basically, you have given us a praxis of the theory of tort law with regard to vicarious liability.
right. So and how it is applicable in India, that we should focus,
Yes,
because we are learning law and dealing with the court cases which we will be implementing in India. So the
yes.
focus has been India, and with that I have tried to throw some lights and do some justice, which I can do it as per
Okay.
ma'am's direction. So I have been able to do that.
I'll
So
invite our chair and the co-host, Professor Salvatore, if he is
yeah.
interested in giving any comment or to raise any query. Even Ashwarya Singh, if you are there, you can also. Rajiv, please do join in back.
Yeah, yes. Thanks so much, Dr. Prema. I'm I'm enchanted by your exposition, and I sorry I missed the exposition of Dr. Rajiv. I just wish to ask something that is belonging chiefly to my main interest, and concerning your lectures. How does the preemption issue, the preemption of the damage, works in both the cases that you analyzed? I mean, let's say in a property law that has been examined by Dr. Surana, how does works the preemption, let's say, from the emission from one landlord? And how does it work in labor work inside the analysis that has been made by Dr. Prema? How does preemption work in this field? This is because in the last days we discussed so much about this kind of advancement that has, beside of everything, has a very ancient roots that has been rediscovered, let's say, from the philosophy of Hans Jonas, who is one of the philosophers who entered directly. This is a rare issue. Entered directly in the analysis of preemption in tort law today. And I'm very interested, and I wish to ask this kind of a subject to both of the speakers. Thanks so much.
If Rajiv sir will first answer his query, sir.
Yeah. So what I understand is, how does preemption law work in India? That is your question. Am I right?
Inside the liability from property law,
Yeah,
let's say,
that's right.
in
Inside of the property.
mission,
So we
yes.
have a preemption, separate preemption act for that. And recently, I had fought a case uh, with regard to preemption, because the property was purchased and was registered in the name of a stranger. So the person, there was a joint family, and the other brother, he filed a case that I have the first right to buy the property. So, but that also works in India, and right of preemption is a very strong right. And but what happened in that case was that already there was a understanding or an MOU or a settlement between the brothers with regard to the division of the property. And also it was mentioned in that settlement that they can do whatever they like with the property. So on that point, we won the case. Now the appeal is pending before the High Court, and that was a long process. And yeah, the right of preemption is there, and there is a separate act for that, the Preemption Act. It is very much there. Any other question you would like to ask about the preemption, I would be uh, more than happy to answer it.
Thanks so much, doctor. Thanks so much.
Yeah. Yeah,
Uh,
Jesh.
I welcome Yuva Chopal News Network. Could you introduce yourself?
क्या मैं हिंदी में बात कर सकता हूँ मैम?
Uh, I have to get it translated. Okay, try. I'll. You continue.
मैं हिंदी पत्रकारिता और जनसंचार का विद्यार्थी हूँ। मैं पटना बिहार से जुड़ा हुआ हूँ।
Okay. All right. So, Ashwarya, you want to ask any question to Madam Rajiv? Any comments, compliments?
Jesh,
Compliments are in
sorry.
welcome, sir.
See, you all have your, lot of network and your own establishments. Rajiv is known for his Rajiv Surana and Associates, a big establishment. Even Professor Salvatore has its own establishment. And they all are dealing with certain kind of, vicarious liability in their own context as employers. So I feel they should raise some question to Prema in
Like
a very.
post, sorry ma'am, in the COVID time, pandemic time, we are seeing lots of cases now between employers and employee because of the economic crunch felt all around the world, not only in India. So many employers have just terminated the services of the employee without giving them any proper notice period also. And even if they are working, they have willingly now accepted to work at 50% of their wages. So it's very sad, but what to do, because it is very uncertain time today. Also, I will not say that pandemic is over and no further waves will come, because we are seeing that in Europe and in I think in China and some other countries of Russia as well somewhere. So still pandemic is there. We
Mhm.
think that it's over. So employer and employee relationship became very, very important. Even Salvatore sir will also in his country, Argentina. He is in Argentina, ma'am.
Yeah, he's
Yes.
located.
So
Currently, he's there
Oh
in
no,
the university.
I'm Anglo-Italian. I will say I am Italian, and but I grown in England.
oh wow. So you have an international persona, I may say, sir.
Yeah, yeah, yeah.
Cosmopolitan, cosmopolitan.
I'm,
Cosmopolitan.
I will not say cosmopolitan, but multi-located, surely.
And being a senior mediator in Delhi High Court, ma'am, I have been dealing with many mediation also between the management and the workers, you see, because many cases like domestic violence, the divorce cases, when it was under lockdown, couples were under lockdown, it's seeing the surge of these type of cases. Then the tenant not paying the rent because they don't have the money. All these cases, it's like bombarded. The courts are now bombarded with this, and also with workers, employers not paying or terminating. So we are dealing now practically, sir will also agree, we are dealing these type of cases much. It suddenly it's like a wave, it has come like third wave of COVID, it has also came as a wave to the courtrooms. So yes, in mediation I try that management will always have a upper hand in some arbitrary manner, you see, because they are the person who is paying and they are the person who is, and the workers are poor fellow. Even they can't hire good lawyers. It comes with its own cost, even getting the justice. And this is a sad part, but yes, what to do. So as a mediator, I have been trying, I have settled like many cases where it's a win-win situation for both the parties. They have gone home happy. Some balance has been drawn between both the parties there. So yes, sir, if you have any question with respect to our country, with respect to something which I can help you with that, answering that.
I would have many doctor, but it is we should open a parallel discussion in another site, I suppose, because uh, I'm very fascinated by the kind of many compatibilities that there are between many systems. Even because in this moment I'm teaching not only civil law and private law to Oxford, but also comparative systems here in Argentina. So it is a parallel world that I love very much, because you know how the same problems have more or less the same answers. This is a very new reception of a law that is always has been considered something like a national system. You know, very difficult to transpose or we should recruit to transplant of institutions or like something like this. I, on the contrary, am seeing how much the same problems generate more or less answer of the same type in many different countries in the world. So we should open a parallel seminar about these, you know. But I thank you, both of you, for your lectures. Thanks so much, and I hope
Thank you.
not to be annoying with mine that is going to come.
Okay.
Actually, now he is
Thank
going to give a talk.
Okay.
So we have to be here.
Okay. I'm sorry. Yes.
Anyway, you're free to go if you feel annoyed. Anyway, ju- just to anticipate that I'm going to, in some sense, to insert what was now it is a 30 years experience in European Union private law inside. Sorry, if I can ask you to mute your microphone because I feel an echo in the back. Can you hear me? I'm feeling an echo in the back, and I don't know if there is another microphone open. Anyway,
Rajiv, mute.
ये बंद कर देना. Yeah, Jayashree. Thank you for inviting me, Dr. Jayashree from BNU, and it is a great effort. And I would like, because I practice in so many fields of law, I would like to contribute to the wonderful work that you have created. And thank you, Professor Salvatore and Prema, you also with the pertinent question that you asked. Thank you so much. Uh, uh, I would like to see all of you again and deliberate on certain important issues that come up. Thank you, Jayashree.
Rajiv, one last statement from our side also to your parents, especially your mother, who is one of the emeritus professor of German language, and she's really an active member, or you may say honorary president of this Indo-German Society. So
wunderbar.
we would like to meet her on screen. Please do. You can come back tomorrow with
Sure, sure,
your
sure.
mom also,
I would
and
be
we
more than
will.
happy, Jayashree.
Yeah.
Yeah,
Sir,
sure.
Professor, I would like to also introduce his father. His father was an eminent, very eminent Rajasthan High Court bar bench advocate, and his contributions
Yeah, he was a
came
senior
to know.
advocate. Thank you, Jayashree. He was a senior advocate and chairman of the Bar Council of Rajasthan, and was continuously the member of the Bar Council since 1987. He never always won the election. What we have here as a in the Bar Council, which is responsible for regulating the advocates and their discipline. So he was continuously the member here. We lost him in the first wave of COVID, unfortunately, at the age of 80 years. And thank you, Jayashree, for remembering him.
Yeah.
He is a great inspiration for us. He's not here with us, but parents never go, and their values and their learnings are always with us. Thank you so much.
Professor Salvatore, actually, his parents were like light for us, because when we were students for 3 years for Madam Surana, they used to just, extend a lot of hospitality to us as students. When I was Jaipurite, in Jaipur I was. So we remember them very much, and so therefore we are still life members.
And I
And
would take Jayashree the opportunity to invite Mr. Salvatore to India, to Jaipur at our place. Most welcome, sir. It would be a pleasure to have you here and
I
host
wish
you uh, in
I
India.
wish our distance would be around the corner, doctor, but it is not, unfortunately. But I must plan. I must plan.
uh,
Yeah.
let's just I will let Prema also, Priyadarshini, to come back. Prema, have you left?
No, no, I'm still there, ma'am.
Prema,
I
could
can't
you
leave
just,
without your permission. I
yeah,
need your.
I want
So,
your background to be into some kind of introduction here, because you are also belonging to a fraternity of judges working in High Court, or your, you may say, ancestors or your parents, perhaps, I think. Because once you told me your father was there in the High Court of New Delhi.
no, no, not my father, but Supreme Court judge. He was a very close relative. Now he's retired. So he was a Supreme Court judge. He was Bombay High Court Chief Justice, Mr. B.P. Singh, and then he retired as a Supreme Court judge. So my father he retired as a director sale. He was engineer. He did from Leeds, England, his engineering from there. So I ma'am always gives me this opportunity. I look forward, and she is a wonderful host and anchor, and so much of warmth emanating from her, from and very beautiful persona ma'am has it. So we can't say no whenever she says you have to come. So I feel honored and humbled to be always a part of whatever ma'am's is organizing. Thank you so much, and I will be always there. So thank you so much. Thank you, sir, and thank you, ma'am. Thank
Thanks
you
to
so
you,
much.
doctor. Thanks to you,
Thank
doctor.
you.
Thanks so
Thank
much.
you. Thank you.
See you, ma'am, soon.
Thank you.
Goodbye.
Thank you, ma'am.
Goodbye. Bye.
So here we have some another one channel India. He's unable to speak in English. So anyway, Professor, you continue with your talk. If he has some kind of technological accessibility to translate at his end your lecture, let him listen.
Yes, I just wish to insert the concept that we were discussing today concerning better the consumer protection inside the long time perspective that we adopted in these lectures of the liability. And adopting as a typical example the German system reaction, we can say, when the European Union directives concerned the protection of consumers. Now we are discussing of an experience that lasted 30 years. So it is, I believe, that is a very interesting experience for this. And concerning the section concerning the liability, the directive that has been received, it is the number 44 of 1999, was on consumer sales, covers the right to demand, subsequent performance if have been not delivered, have been delivered not conforming goods, and the right to termination of the contract, and the right to a reduction of the price. So we are the first articulation concerning three kind of remedies that we have facing liability in case of non-conforming goods. It does not concern, let's say, issues related to the passing of mercantile risk and the right to recover damages. The directive is a minimum harmonization measure has been defined, in the sense that it is it inserted at that time in already existing systems of protection that is that is part of that was part of the already existing systems in all the European Union countries. We have in Italy, let's say, for example, there was a true microsystem belonging to the beginning of the modern civil code in Italy that belongs to 1942. This directive has been used as a model for the subsequent reformation in German civil code, in order that for the contract of sale, of course, in that for that matter. Unlike the 2002 regulations in England, these structural elements that has been focused in the directive have been implanted into the heart, let's say, of a German law of obligations. As a result, this was the great difference between the different reception, let's say, of inside an already existing system, like the Unfair Terms Contract, Unfair Terms Act, already present in England, and the already existing system in Germany at that time. As a result, a few of these new norms provisions were necessary to deal with the special requirements of consumer sales. We can group upon 5 norms that go from the paragraph 474 to paragraph 479 in German civil code. The so-called grosse Lösung, or big grand solution. Who reduced the number of the overlapping resumption rule, which is the main difficulty with the approach to the implementation in England in English law. Let's say this kind of overlapping that was that entailed a long time process of adaptation of the European Union normative with already existing English protection law for the consumers. However, this so-called grand solution approach, what meant at the time, meant that the European law flows inside the domestic law, and that impact of European law, it was maybe in the modern legislation 30 years ago, the most important impact of European law in civil law, extending to beyond the areas to which it plans to apply, because of course every kind of insert like this imply a systematic reassessment that imply by itself a more general reassessment that can belongs not only to the spatial field, the special Bereich where it applies, but also to many other fields, and of course to many ancillary systems, like, let's say, the civil procedure.
So what does it mean, ancillary systems?
Sorry?
This word you've used, ancillary systems. Can you see on screen of yours? I've done
No.
the captions on.
No. It's me.
Okay, continue. If it'll come again, I'll remind you. This some
Yes,
phrase you've used, ancillary systems.
If you can text in the chat, I will be very grateful. You know that I can.
Okay. You used a word like this.
ancillary systems. Ancillary systems, I mean, let's say,
Okay.
the ancillary. It is in the sense of the, the closer systems. If if we have some kind of protection, uh, uh, if we see as I believe we must, the concept of a sale as a concept that entails, of course, a larger inclusion of the system of sale, we cannot only limit some kind of a modification only to the spatial field through which the reception of the legislation should be applied. But of course, this entail a larger application because it entails some form of protection that are justified to be applied to other fields. So, and this entail, of course, not only the system that to be, enunciated as concerned by the European law normative, but also many ancillary systems in the sense of more in general the sale of goods, not only in the case of consumers as part of the contract, and of course procedure, civil procedure, in the sense that we have some form of, let's say, the most easy case is that, as we already have seen now, presumption works. Okay, if a presumption works in this system, of course, we have the effect of the reception of the European Union law inside the civil procedure, because we must modify for the most common example, and there is the reverse of the burden of proof. So we cannot isolate, as can be done in other discipline like criminal law or other systems like this. In civil law, we have an organic reaction of the entire body of normative, the normative body, to the insertion of a very important modification like this. And so in this sense, ancillary systems is the most important form to see how a normative go inside the system and how the system, let's say, is able to react to this insertion. And this is, of course, much more detectable in the sense that this directive affected not only the contract of sale, let's say, but the remedies for breach of the contract of sale. That was a different system. These remedies are to a great extent derived from the general principle for breach. Okay, so this is to see the magnitude. This is just to focus and to having under regard the magnitude of the reception of a legislation of a European Union inside an already existing and enforced the system like the German one. The right to terminate the contract, let's say, an essential aspect of the rights granted to the consumer in the Article 3 of the directive, is defined in the general part. Okay, it is in the general part of the German Civil Code, that is paragraph 323. It is not part of the special legislation received under the Consumer Protection. So, please, Doctor.
You have mentioned three of the directives that some kind of have correlation with the principle of breach.
Yeah.
What are the three directives?
Now, Article 3 of the directive.
Okay, Article 3
Article
of the
number 3, yes.
And directives are the duties?
This is the Article 3. It is it is not a duty. This is a right to terminate the contract in case of non-compliance. Okay, but this is part, as part of the concept of resolution of the contract. Okay, it is a very answered remedy, part of a normal civil code, of common civil code, and that in the case of Germany is part of the original paragraph 323.
Okay.
that has been provided in general, of course. When I say in general, what I mean between two subjects not properly defined as consumer and professional. Okay, because in this case we must apply this directive to a special area defined by two status of the parties. On the contrary, in the general principles, we must only apply this. We have to apply this to all as a general principle, to all the contract in which there are two parties, not better or more particularly defined as professional and consumer. Okay, so in this case, we have this kind of not traumatic, non-traumatic coherence between these two norms. Okay. That is, doctor.
Yeah. Okay, today you have got very short lecture and easy lecture.
Okay.
Nice.
See
We are
you.
winding up.
Talk to you later. If you have not any other question.
No, I don't have any other question. Only thing is that I go according to your thought of mind that you want to extend to me or to our whatever in our recordings. So actually, why did you today shorten up your Consumer Protection Act and its liability in such a concise manner? Why?
No, it is not so concise. It is simply an opening. It is simply to insert the basic element of the problems. I will continue if you want, because
Yes, you should.
there are many other issues that are.
You have
That
still 15 minutes. 15 minutes.
Yeah. Because let's say always following this principle of of application of something that is particular inside something that is more general. That is one of the relationship between general and particular or special is something that belongs normally to the process of interpretation of a jurist. Let's say that the right to recover damages instead of performance follow this same pattern, okay, between the general aspect and the particular aspect given by the reception of the European Union directive, shaped by the approach adopted in the directive. I'll talk only in a indirect way, since it is not covered by the directive itself. So, for example, in this area, the relationship between the particularity and the generality must be discussed around two issues. The first one, to what extent the directive determine the approach in these provisions of German law that are not limited to consumer sales. And this is what we are discussing many times, until how far we can limit the application of some beneficial norms when the presupposition, the subjective presupposition, like to be a consumer, is not applied. Let's say in a contract between professionals. Okay, we are discussing in this case of the damages instead of performance. Okay, we are discussing, of course, before the reformation of the German civil code that took place in 2002. Okay, and 2002, the Schuldrechtsmodernisierung. So this is one of the systematic level to focusing on which it is important to see how the civil law works in this case, when we extend or we cannot extend the protection to some kind of subjects that are not exactly the same figures that are provided by the legislation. And secondly, for example, we must also discuss the special rules applicable only to consumer sales. More in general, and I believe that more in in a more general fashion. So go extending more of out of the of European Union systems and having regard to a more general interest, we should discuss how this kind of a provision, when they enter in a special system, adopting some form of a protection, having regard to some kind of typology of subjects, cannot or can be extended to other form of protection. Uh, it is not matter of it is not only matter of consumer contract or patrimonial protection, but it also applies to all this connection between a status, status in Latin, that is more correct, status out has been termed in English, between status and protection. If when we protect the status, maybe commercial, maybe whether commercial, whether it is a personal, patrimonial, or something, how far this kind of protection can or cannot be extended to other form of protection, or to other typology of status, or outside any status. How the particular modify the general in some sense, and so how the system adapt to the new introduction, evolving itself and absorbing. This is, of course, my perspective, that is an organic perspective of the civil law. That I cannot see that is more than this, more than my vision. Upon concretely, I will find confirmation for this perspective, looking at this of the answer that we can give to this question that I just put it. The first issue is complex. We can only discuss some aspects, but what we can say, that directives as a general rule do not have direct effect. Okay, the general rules and contained in directive is not directly enforceable. They must be implemented by national legislator. So the reception is not automatic by the judge, let's say, who cannot be invoked to apply the directive when it is general. On the contrary, it is obliged to apply when it is sufficiently determined and precise. In this case, we have a general normative, and that so the judge cannot be invoked to apply it. Only national legislator must. Please, doctor, please. I can't hear you. Maybe you muted your microphone.
Yes. So if there is a sort of a non-compliance, and then the with regard to certain directive that you are saying in the consumer.
No, we have a more. We have two. Since the beginning, we have at least two categories of European, of supranational legislation, European Union directives. They can in order they to be immediately and directly enforceable in the national system and to a concrete case, they must be clear, precise enough, in order that they clearly and define the right and the legal position more in general, in order that they can be invoked immediately by the judge, who is obliged to apply them. On the contrary, when there is a more general directive, when the concrete situation has not been concretely defined by the original legislation, okay, issued by the European Union, in order they to enter in the national systems, they must be applied and received, annulled by the national legislator. Okay, through an internal legislation. Okay, who that is a college to implement the European Union directive in this case. So we have a two-phase implementation. And so only after this kind of reception of national acknowledgement, we have the legislation, the internal legislation, recognizing the European Union directive and then enforcing the provisions in the national systems. And this is the case of the consumer protection under general, and of course for the part that we are concerned today, for the part of liability for non-conformity of the goods.
So,
Okay.
for example, if any kind of import or export is there in your through your European Union, then how this general and the particular performing and non-performing
We have a
directive will apply?
no, we have not a we have not a limitation on the field, on the ambit. Okay, it does the only demarcation concerns the technical of legislation. If the European Union issue a directive that is clear and precise enough to define subjective situation, this is immediately enforced, okay, by the judge, even in the absence of the national acknowledgement of the directive through an internal legislation and implementation. I can go immediately to the judge and saying, look, that there is a regular a ruling directive in the European Union that has this character. You must apply this legislation. Okay. The other type is the general directive, the general and not precise directive, who is going to issue an harmonization through guidelines. Okay. This kind of directive cannot be implemented directly by the judge. So
Okay,
I
yeah,
cannot invoke it. I cannot invoke it directly by the judge in the nation that is the single country member of the European Union. They need to be implemented through a national acknowledgement, through a national legislation.
Right, sir. So now, can I tell you about tomorrow's program? We have got actually
Yeah.
three speakers plus two kind of VC, vice chancellor kind. So 5 speakers besides you. How will I do? So though like 3 are majorly speaking because one is on drug.
Yeah.
Some drug
Tomorrow we have a liability under contract.
means that you would be talking about.
Add orders.
No, but first you understand that how I.
No. I'm okay. I'm fully compliant with your orders, Professor. Yes, I'm absolutely okay.
No, first you listen to me what I'm saying. There are 3 speakers. If I start at 6 o'clock, so one is from Mohanlal Sukhadia University, one is from pharmaceutical drug controller doctor. He's a doctor. Another is I think he's also a quite good expert. He would be talking in some liability 3. Then there are 2 guests and honorable guest or special guest. They are both vice chancellor kind. I think both are from Pune or Bangalore. So suppose if I allow them to start for the program from 6 o'clock to 6:30, then 6:30 to 7, 7:30 to 8. What about you? How will you means come in between? Or what will you do? What will be your role tomorrow? Because you're the co-host.
I can do whatever you want. I can enter tomorrow morning. I am more free than today. I can enter what time you prefer.
I think you should enter by 7 o'clock at any cost.
7 o'clock at any cost. Let's say.
Because if
7
I started,
Yeah, now by you it's what time is it now?
at my end, it is quarter to 9. Quarter to 9.
A quarter to 9. So let's say 9.
2 hours
Let's
before.
see. Oh, okay, I will calculate anyway.
No, 2 hours before. Now quarter to 9, then 2
Now,
hours before.
now we have a 9 hours and 30 minutes of difference.
So, for example, you joined at 11 o'clock. You joined tomorrow at around quarter to 10.
A quarter to 10. It is.
Yes. I think you should join tomorrow at quarter to 10. Means
Okay.
you have to be like an umbrella tomorrow to give me a shelter. Every day I'm holding all the speakers on my shoulders through my voice.
Okay.
So
Okay.
tomorrow
Okay.
you have to be there as a protector, giving some kind of, what I'll say. I'm working, of course, I'm quite expert in moderating, but I need a kind of a legal expert to
Okay.
carry on with those guys.
I will be this guy.
So tomorrow, so when your night ends, you sleep early, you get up early, get ready quick.
Okay. 9:30 I will be there. Okay.
Right, sir. So today I take leave so that you can finish up with your other task. Even
Yeah,
I have to prepare.
I go to virtually. I go to Oxford now. By other lecture.
Yes, sir.
Through Zoom.
Right, sir. Right, sir. And I have to also prepare tomorrow's brochure tonight only.
Oh, okay. Okay. 9:30 tomorrow.
Yes, sir.
Thank you very much, Professor.
Bye,
Thank
sir.
you very much, everybody. Bye bye.
Bye bye. Thank you.
Bye.